Friends, good afternoon to all of you present for this important occasion of orientation program. This is the first lecture for this quarter from January to March. It is my pleasure to welcome all of you for this orientation program on IPR and about the patenting. And we have with us Dr. Karna Sagar, our family member and Senior Director of Research and Patents. Friends, before I formally welcome all of you, we should be aware of the patenting process. Recently, Students Innovation Club of Pharmacy College also arranged this talk. And this is because in the Indian Patent Office, if you see 45,000 patents are filed in a year, unfortunately, only 13,000 are filed by Indians. The rest, about 32,000 are filed by foreign nationals. Although we have IITs, NITs, several research institutions, Government of India is spending a lot of amount and also creating institutions so that this patenting becomes an important way of protecting our knowledge. Knowledge is for sharing. This is an old saying in our Indian context, but today, since we are competing with other countries, we have to protect our knowledge, and this mindset has to be removed. And therefore, this IPR and protection of our knowledge is a patent is an instrument for protecting our knowledge. And today we have with us Dr. Karna Sagar, our own family member and very senior professor in the university, looking after our research and patents. And today he is also heading there in the Technology Enabling Center of the Nitte University. Sir, on behalf of the Institute Innovation Council, I am very glad to welcome you. And I welcome our Honorable Vice Chancellor and others. Our coordinator for this program is Dr. Praveen Kumar Shetty, our Director of Research and Development. And I welcome all the members of the Institute Innovation Council, Professor Nitte, Pro Vice Chancellor, our Registrar, and all the student members and faculty members of our Nitte University family. Before formal introduction to our Dr. Karna Sagar, may I now request our Vice Chancellor to provide opening remarks on the orientation program on intellectual property right. Professor Satish Kumar Bandari, Honorable Vice Chancellor of our university.
Good afternoon, Dr. Vidya Karna Sagar, our own colleague and advisor for research and patents of the university, who is the guest speaker for this occasion, and the moderator and director of direct technical research and president of Institution Innovation Council, Professor Dr. Sriniketan, and Dr. Praveen Kumar Shetty, the director for research and development, and all my colleagues from Nitte deemed to be university, and all the participants this unique program organized by the Institution Innovation Council. Ladies and gentlemen, I'm extremely happy to be part of this inaugural function of this lecture series organized by our Institution Innovation Council, which was started very recently and it is doing a lot of good work. I should congratulate once again this Institution Innovation Council, its president and its members for organizing very innovative programs. And this particular lecture series is concentrating on various aspects of research, intellectual property and patenting. And this particular webinar or lecture is regarding intellectual property rights with the focus on patenting by the institutions. Intellectual property is the outcome of human genius, creativity and power of imagination. To me, quality higher education must aim at developing good, thoughtful, well-rounded and creative individuals, and must form the basis for knowledge and creation and innovation. Today in India, we have more than 1,000 universities and about 50,000 colleges with the gross enrollment ratio of 26%, and which is 1.3 billion population. We have successfully created over the years a large knowledge society, but unfortunately we have failed to nurture the critical thinking and innovative bent of mind among our youth. What is needed is the vast knowledge which you have created to be converted into skill, innovation, and intellectual property. Since 2004, if you go by statistics, there's a tremendous growth in intellectual property in the world. Mainly it's led by China. Almost 50% of the intellectual property is the applications. It is by China. If you go by 2019 statistics, that shows that India is at the 11th position in the world ranking, with China again leading consistently for the last so many years. And India is in a very lower position compared to even small countries like Korea and Singapore. As Sriniketan said, there is lack of awareness about protecting your intellectual property. With the new initiatives of Government of India, now there is a lot of awareness has been created among the people. People have started to realize that importance of innovation, incubation, and entrepreneurship. Also, applying for intellectual property. Number of intellectual property applications also gradually increasing, and it is gratifying to note that India has become startup hub in the world, and it's contributing almost 30% of the Indian GDP. Thanks to the various government initiatives. As you all know, any country to become very progressive and developed, the people should be innovative and they should be having entrepreneurial mindset, and is a need of the hour. As you all know, Nitte University has taken a lot of initiatives and has given importance for patenting the intellectual property right of the faculty and the student. And recently it has come out in the startup policy. It is in the final stage of drafting and enactment. I'm glad to note that in the year 2020, 7 patents have been published under the leadership of Dr. Idda Karunasagar, our advisor for research and patents. I congratulate him for this unique achievement, and we have targeted a higher number this year. I think I hope we will reach double-digit figure in this year in applying for patent. I would like to place on record my sincere appreciation to our Institution Innovation Council, President Mr. Sriniketan, for organizing this very unique webinar about intellectual property and patenting. I hope the talk by our colleague Idda Karunasagar will be very fruitful in creating awareness about the recent government guidelines in patent and intellectual property right. And I hope it will ignite out-of-box thinking among our faculty and students, and start and create intellectual property and document it and apply for patenting. And I wish great success for this program. And once again, thank the Institution Innovation Council giving me this opportunity to address my colleagues. Thank you very much.
Sir, thank you very much. May I now request Dr. Praveen Kumar Shetty, coordinator of this program, to formally introduce Dr. Idda Karunasagar and welcome him, and to start the orientation lecture. Dr. Praveen Kumar Shetty.
Thank you, sir. Thank you. Honorable Vice Chancellor, sir, today's speaker, Karunasagar, sir, and IIC President, Dr. Sriniketan, and our Pro VC, Dr. Muditaya, sir. Very good afternoon to all. So this task of introducing our guest speaker is a great privilege to me. I know it's a difficult one, but I thought he's a man of simplicity. I feel proud to introduce him to everyone today. If one one takes a closer look at the alchemy of this achieving person, two of the several things are most evident. That is perseverance and hard work. Our guest speaker, Dr. Idya Karunasagar, obtained his master's and PhD degree in microbiology from Mysore University. Later, he had postdoctoral research from University of Maryland, USA, University of Sendai, Japan, Natural Resources Institute, UK, and University of Würzburg, Germany. He was also a Humboldt Scholar from 1991 to 92 and a visiting professor from 1993 to 2005 at University of Würzburg, Germany. He served in various positions at the College of Fisheries, University of Agricultural Sciences, Mangalore. So then he became the Director of Research at Karnataka Veterinary Animal and Fisheries Science University, Bidar. He also served as a Senior Fisheries Officer at the Food and Agriculture Organization, FAO, of United Nations, Rome. Following his retirement from FAO, he joined Nitte, deemed to be university, as a Senior Director, International Relations in 2017, and he is currently the Advisor of Research and Patents at Nitte, deemed to be university. Dr. Idya Karunasagar has guided over 30 PhDs and 45 master's degree students. He was the recipient of several awards, to name few like Rafi Ahmad Kidwai Award in 2005 from Indian Council of Agriculture Research, New Delhi, Aquaculture Award from Marine Products Export Development Authority in 1993, etc. He has over 220 publications in refereed national and international journals. He has 15 book chapters, 6 patents, and 3 commercialized technologies. On a final note, he is also a fascinating individual, and we are very grateful for his presence among us today. Without further ado, please join me in welcoming Dr. Idya Karunasagar, sir. Welcome you, sir. Thank you. Thank you, Vanita. So, over to sir.
So, thank you very much, Dr. Praveen, for the kind introduction, and also thanks to our Honorable Vice Chancellor for the nice introduction that he gave for patents. So, that has set the stage for learning about patents, and I am also thankful to Dr. Sriniketan for organizing this program, which I hope will be helpful to all the faculty and students. So let me start the presentation by sharing my screen. Are you able to see the screen?
Yes, sir, we are able to see.
Yeah.
Okay. Okay, so the topic of the day is intellectual property rights with a focus on patenting in India. So I'll give an introduction on how patenting is to be done and what are the different intellectual property rights. So what do we mean by IPR and what are the things included in it? So first we'll start with patents. A patent is an exclusive right granted for an invention, which is a product or a process that provides in general a new way of doing something or offers a new technical solution to the problem. So what is important here is anything new. So we have to demonstrate something new to be able to get a patent. So it has to be either a new product or a new process. And to get the patent, the technical information about the invention must be disclosed to the patent office. Of course, you may think it is confidential. Yes, it is confidential, but it has to be in the custody of the patent office. So the patent office has to have all the information about your invention if the patent office is to grant a patent. And then what we have under IPR is also copyright. Copyright or an author's right. Many of you are familiar with this because you are all publishing, and you know when you publish, you transfer your copyright to the journal. So, but copyright is again a legal term, used to describe the right that creators have over their literary or artistic work. So there are a number of things covered under this copyright. Now, for example, if you have a method of teaching that does not qualify for patent, but you can cover it with a copyright. So there are certain things which cannot be covered by a patent, but you can cover under copyright. Of course, this varies in different countries. When I was looking at what is patentable in the United States, even the method of teaching is patentable, but in India it is not patentable, but it can be covered by a copyright. So work covered by copyright range from books, music, painting, sculpture, and films, or computer programs, databases, advertisements, maps, technical drawings, etc. And then you also have under IPR, trademark. Trademark is a sign capable of distinguishing the goods or services of one enterprise from those of others. So we have trademark, and of course even universities have trademark. We also have a logo which can be protected by a trademark. And then we have another important IPR, that is geographical indication. Now, when we look at Indian economy, agriculture is very important. So we export number of agricultural commodities. Basmati rice is an important item that is exported. And then tea is another commodity that we export, and we are aware that there is a geographic indication for this. So when you say Darjeeling tea, that means the product has some specific geographical origin and possesses qualities or a reputation that is due to that origin. So that particular property of that product comes from that region. So in that case, you can have a geographic indication. So this is again very important to protect a product in trade. And we are also aware how US was trying to have patent for taxamati instead of basmati. So there are a number of these kind of issues in international trade. So when it comes to international trade, we need to be aware of international agreements a little bit. Now, of course, all the trade in the international scenario is under the purview of the World Trade Organization. So here, this map shows members of WTO, mostly in green. And then you have, because European Union is a region, so it acts as one block. So there's a different color for the members of the European Union. And then you have some countries which are in blue. They have not yet become members of WTO. They are observers. So they are in line to become members. So they are in the process. And there are very few countries, probably like Somalia and other countries, which are still not members of WTO. But most of the countries in the world are under WTO. And WTO member countries have agreed on trade-related aspects of intellectual property rights. So this TRIPS agreement comes an important point, and particularly in pharmaceutical products. As you know, when the Novartis case came up, so they went to Indian court saying that India is violating the TRIPS agreement. So we need to be aware a little bit about this TRIPS agreement when we are talking about intellectual property rights. And when we talk about patents, well, what is the jurisdiction? So do we take patent in India, or do we have to take in other countries? Can we take simultaneously in different countries? So we need to think of this aspect. So when we take patents, patents have a national jurisdiction because each country has a patent law. So patents are issued as per the national patent law. But then there is a patent cooperation treaty, which is an international treaty with more than 150 contracting states. So this patent cooperation treaty makes it possible to seek patent protection for an invention simultaneously in the large number of countries by filing a single international patent application instead of filing several national or regional patents. But the granting of patent still remains under the control of national or regional patent officers in what is called a national phase. So this is important, particularly if you have a product, a pharmaceutical product, for example, or a diagnostic kit, which may have application globally. So you are thinking of protecting it not only in India but internationally, then one can think of this. But of course, this also involves cost. So if you want to take an international patent, that involves additional cost. So we need to think of the returns that you can get by getting this international patent. So this slide summarizes the pathway for getting an international patent through a PCT. So you have an invention on the left side, it starts with an invention. So you make an international application. And this can be filed with the receiving office. So the receiving office could be the National Patent Office, or Regional Patent Office, or the International Bureau. And then once it is received, if it is for PCT application, then it will be verified by international authorities. There are international authorities like the international agencies that look for the prior art search. So they look at the eligibility for patenting. So and then they make an opinion whether it is patentable or not. And this is reported to the World Intellectual Property Organization. So like you have the WHO for health, we have FAO for food and agriculture, we have World Intellectual Property Organization, which is the International Bureau for Intellectual Property Rights. And then it is published in the patent scope of WIPO. And this is communicated to the designated officers, national or regional officers, and then patents are issued on this. The time required for this is also illustrated in the lower part of the slide. So it takes some time to get this type of international patent. But there is a possibility of getting this type of international patent. So here we have illustration of WIPO website, and what are the things, resources that are available. So you have various services available from WIPO. So there's a patent database, so you can get information on what are the patents awarded in United States or China or Canada or European Union. So this is an important resource for us. And also about policy. Now, for example, if you want to patent something in, say for example, in Africa, then what is the patent policy of the countries in Africa? So you can get information on this. So this is a very important resource when it comes to international patenting. And this is an example of a patent scope, the database from this WIPO. So you can get information on patents awarded internationally by these international organizations. Now, this slide illustrates the position of various countries in 2018 on patent applications. So, China tops the list, and if US comes second, we are in the 7th position. And you can see even the difference between US and China. China is nearly 3 times of United States. So, it is still a very I'm sorry, it's 3 times, yeah, and it is more than yeah. You can see the difference between India and China. It is very stark difference. So we need to go a long way in catching up with other countries in filing patents and establishing our position as a country with innovation. So this is why all academic institutions need to be giving more emphasis, and now Government of India is also paying a lot of attention for patenting. So since patent is a legal right and it has to be under the international agreement, there has to be national policy and regulation. So in India, we have the National Intellectual Property Right Policy. This is available from the website of the ministry. And we also have the required legislative framework for IPR. So all these information can be obtained from the Department of Industrial Policy and Promotion. So we have the Patent Act, which is being amended from time to time as there is requirement. So the Patent Act was last amended in 2005. And then under the Act we have number of rules, patent rules. So Patent Rule 2003 was amended in 2020. And then we have also the Designs Act and the Design Rules, and the Trademarks Act and the Trademark Rules, and the GI Act and the GI Rules. And under the Department of Education, you have the Copyright Act, which was amended in 2013. So we have the legislative framework that is required for intellectual property. Now, in addition to these regulations, there are also legislative framework from other ministries which will influence the patenting. For example, Ministry of Agriculture. Now, India being a predominantly agriculture country, so we need to protect the rights of farmers. Farmers need seeds. Their livelihood is dependent on availability of seeds, so we need to protect their rights. So, Protection of Plant Varieties and Farmers Act has been adopted by India, under which an authority has been created, Protection of Plant Varieties and Farmer Right Authority of India. So they will decide on the plant varieties that should be made available to farmers freely, so that they can produce these commodities and earn their livelihood. And then under the Ministry of Environment and Forests and Climate Change, we have the Biological Diversity Act 2002, and the authority, National Biodiversity Authority, which is implementing this Biodiversity Act. Now, any patent related to any biological material has to be cleared by the National Biodiversity Authority. It may be something which is very common, which is not protected, but still any biological material, patent related to this biological material has to be cleared by the National Biodiversity Authority. And then we have the Ministry of Electronics, Communication and IT, under which we have the Semiconductor and Integrated Circuit Layout and Design Act of 2000. So this shows the layout of the institutions related to these patents, designs and trademarks. And you have the patent office, head office is in Calcutta, and we have branches in south it is Chennai, then for north we have in Delhi, and in the western part we have in Mumbai. And then you have the design office in Calcutta, the trademark registry, again there is a head office in Mumbai, and then there are other offices. The geographic index registry is in Chennai. And in addition to this, we also have an intellectual property training institution. So the National Intellectual Property Institute in Policy Management Institute is located in Nagpur. So they conduct number of training programs. So people can attend this training program for a very small fee. And now, fortunately, most of these training programs are online. So you can register for these training programs and undergo training conducted by this intellectual property training organization. So the various legislative framework and acts and rules you can obtain from the website of Department of Industrial Policy and Promotion. So now let us look at what are the salient features of the patent law in India. So we can have patent for a product or a process. So you can have both included. So now, for example, when you think of what you do in the laboratory, you may be performing or you may be doing a particular way of extraction. So you may be extracting something by a different process, which is much more efficient than the existing process. So though the product is known, you can still patent the process because you are arriving at a product much faster than the existing process. So you need to think of this type of process patent also. It could remain to, which could pertain to even say some laboratory buffers or DNA extraction methods or various other procedures that you perform in the laboratory. So these are eligible for process patent, and it can also relate to say extraction of a bioactive compound from biological material. So though the product may be known, you may have a new process for obtaining this product. Or you may have a new product. So you need to think whether you are trying to protect a product or a process. So both are possible. And the term of patent in India is 20 years. Of course, globally also it is 20 years. That's why we have the business of generic drugs. So whenever a patented drug comes out of its patent protection, then manufacture of this drug by other companies can be permitted. So generic drug companies are looking for patents that are nearing expiry date, and then they ask for permission to manufacture these drugs. So you cannot go beyond 20 years. But then there are ways in which some pharmaceutical companies try to extend it by trying to modify a molecule and things like that. We will talk about it later when we are talking about some of the exclusions in our Patent Act. And the patent application, when it is submitted, you can submit a request for examination, and you can have opposition. You can oppose a patent application by somebody else if it infringes on your own intellectual property. So, but if you have evidence that you have done something prior to what is with the patent office with somebody else's claim, then you can oppose it. You can oppose a patent application before the grant of patent. Normally, once the patent is published, then it is openly available. Then you can, if it infringes on your intellectual property, then you can oppose it. Or even after granting a patent, even post-grant opposition is possible. After the patent has been granted, if you provide evidence to the patent office that this patent is not new, you had earlier found this and you have evidence of that, and then you can oppose it. So they may revoke the patent also, depending on the evidence available. So there is possibility of both pre-grant and post-grant opposition. So this is very common in various industries, because they are always looking for what the competitor is doing and how they can get an edge in the marketplace. So this is very important to understand that it is possible to oppose a patent application, either before grant or even after grant. And there is also a mechanism for fast tracking of appeals whenever there are any oppositions and claims or counterclaims. And then there is provision for protection of biodiversity and traditional knowledge, like Ayurvedic medicines, for example. So many things are known in tradition, so we need to protect them. So many times in India we say, okay, we have this traditional knowledge, but then how do we show that this traditional knowledge existed? So now what the government is doing is they are trying to document this traditional knowledge so that no other country can ask for patent for this. So we are aware of number of similar cases that have occurred where people from other countries were trying to patent what was known in India from the traditional knowledge. So we need to protect this traditional knowledge and document it, so to show that it existed. And publication of patent applications after 18 months is a normal process. Later we will see how to fast track this. So these are some of the features of Indian patent law. So there are also safeguards under the patent law. So there is a possibility of compulsory license to ensure availability of drugs at reasonable prices. So if there is a life-saving drug that is protected by a patent, then the government is entitled to provide license to companies to manufacture this at a reasonable price. So it should be available to the public because it's for public good. And then there is a provision to deal with the public health emergency now, like for example, COVID is a public health emergency. So the discoveries related to COVID are to be made available for the public. And then there is possibility also of revocation of patent in public interest and on security consideration. Now suddenly if you find that something is a bioterrorism threat, then of course you can revoke the patent related to that. So there is a possibility of these things to safeguard the public. So let us look at the scope of the patentability under the Patent Act. So what is an invention? So this is described in the Patent Act section 2. So an invention means a new product or a process involving an inventive step. So this is what is important. So you have to demonstrate that there was an inventive step. So your innovation was involved, your discovery was involved, and it's not something natural or well known to the experts in the field. And secondly, you need to show that there is possibility of an industrial application. Otherwise, what is the point in protecting it? So, of course, normally we say knowledge is to be shared, but if the knowledge has an industrial application, then you are entitled to protect it because you have invested your time and you have created it, and so you need to get the benefit out of it so that others do not steal it. Of course, if we look at the history of patent, it's all started in the 18th century. Of course, a lot of early discoveries were, or even applications were not patented in Europe, but of course it all started in the United States. United States had the patent law in the 18th century, and they started protecting these type of discoveries. And of course, as the Industrial Revolution came, then it became very important to protect whatever has an industrial application. So, an invention relates to a process or product, as I mentioned. So, it should be novel and involves an inventive step and should be capable of industrial application, and that it should not fall under section 3 and 4. So, there are the section 3 and 4 covers situations which exclude patentability. So, we need to be aware of little bit these issues. So, an invention published in India or elsewhere is not eligible for patent. So, this is what the scientists should be aware. When you want to publish, you need to be aware that you should first file a patent application. And even though your work may not be complete, you can still file a provisional patent application. So, your whatever you are claiming as discovery should not be in public knowledge or prior public use within India. And it should not have been claimed before in any specification in India. So, there is an exception. A 12-month grace period is provided. So, there are conditions for this. So, if the publication has happened by another person without the knowledge of the inventor. So, for example, if the group has been working on certain things, the main people who are working on the invention, they have not published it, but somebody else who had knowledge of this, they have published it. So, in that case, if you can demonstrate that publication happened without the knowledge of the inventors, then within the 12-month grace period, you can still show, if you can demonstrate that you are the inventor, then you can claim for patent for this. And another situation where exemption is provided is if you have communicated this your invention in a report to the government as part of an investigation or a funding agency report. Many times research may be funded by government agencies like DBT or DST, and you have to communicate your research findings to the agency. You need to provide annual reports. So you might have provided some information to the government as a part of this funding agency requirement. So though it is there in the report, which is revealed, it has been seen by quite a number of people, but still you can claim exemption because this was part of the requirement and you are reporting to the government or the funding agency as a part of the requirement. But then it has to be done within this 12-month period. So grace is involved, but then you have to be aware under what situations you can get this grace period of 12 months. So, to avoid this, if you have a discovery or an early stage product or process, you can file a provisional patent application. You don't need to provide much detail. You just give a brief summary of your invention and then file the application. So the patent office will not look at this application. They will look only when you submit the complete specification, and you have 12-month period for providing this complete specification. So the complete specification and patent claim should be submitted within 12 months of submitting this provisional application. So another feature of any invention, it involves a technical advance as compared to existing knowledge, have an economic significance, and makes the invention not obvious to a person skilled in the art. So you may say this is something new, but an expert in the field may say, no, this is not new. We all know this. So this is a matter which is obvious to an expert. So you need to avoid this kind of situation and demonstrate that this is not something which is obvious to an expert in the field. So what are these sections, including exclusion? So under these sections, you have what are called frivolous inventions. So a machine that gives 100% performance. So no machine can give 100% performance. Or a machine which is moving without any source of energy, or something which is contrary to a well-established law. So you cannot claim any patent to these kind of claims in your invention. And also commercial exploitation or primary use of invention which is contrary to public order. So if you do something which like a gambling machine or device for housebreaking or something which is not in public good, then patent can be denied for that, even though it may be a new device that you have discovered. And there is also exclusion for commercial exploitation or primary use of invention which causes serious injury or prejudice to health. It may be human health, animal health, or plant life or health, or environment. So here, this exclusion relates to biological warfare material and cells, embryonic stem cells. So you cannot have patent for these things which may have other applications. And also genetically modified organisms. So there is exclusion under this section 3D, excludes patent on genetically modified organisms. But you can patent genetically modified organisms that are for public good. So this section talks about genetically modified organism, exploitation of which could be contrary to public order. Now, for example, initially there was a lot of discussion whether coronavirus causing COVID was something like a bioterrorism material, a genetically modified organism. So you cannot have patent for those kind of organisms which may have harmful effect to human, animal, or plant life. But later we will see genetically modified organisms which are having application for good, they can be patented. Now there is the case of the first genetically modified organism to be patented was a microorganism. It was a Pseudomonas, and General Electric was the company in the United States which got patent for this. And the scientist involved was of Indian origin, Dr. Anand Chakrabarti. So what he did was he developed a genetically modified Pseudomonas which can degrade petroleum. Now petroleum contamination of oceans is a very important problem because a lot of shipping activity takes place, a lot of oil is transported in the ocean through containers, and we have heard about large scale oil spills. So you need something to quickly remove this oil. So he developed a genetically modified Pseudomonas which could eat up oil. So that was the first case when US allowed patenting of a genetically modified microorganism. So it's not a naturally occurring microorganism, a modified organism, but the modification is doing some public good. But if the modification makes the organism more pathogenic and harms human or animal life or plant life, then it cannot be patented. And section 3C also includes any discovery, a mere principle, discovery of a principle or natural observation, discovery of something new. It may be a new element that you have discovered, or a new mineral which you have discovered, but which is existing in nature. So you have only observed it, but you have not created it. So these things are not eligible for patenting. So this 3C again talks about genetically modified organism. So as I mentioned, genetically modified microorganisms are patentable. And also now we know that there are a number of plants which have been patented, like BT cotton. So here again the modification is for public good, because you are trying to eliminate the use of pesticides. So you are trying to make the plants more resistant to the pests and minimize the use of pesticides. So such genetically modified organisms can be patented if they are for public good. And section 3D excludes mere discovery of a new form of a known substance, which does not result in the enhancement of the known efficacy. So efficacy of a compound is very important. So even if you discover new form of a substance, but the activity is similar, then it's not qualifying for patent. So this includes salts, esters, or others which are metabolites. So there is an example of this Novartis case where they claimed a example of a modification, chemical modification. They tried to say it is a new compound, but then it was shown not to be a new compound. So that was rejected. So these salt esters and these are not patentable. And another thing that is important also in the biomedical field, now we are talking about repurposing of drugs. So if you find new application, new property of a known drug, then of course it's not eligible for patenting, because you are not modified it in any way, but you are only found a new property for it. And a combination of substances, you may combine two things to find something, but if the activity is just an admixture resulting in only aggregation of properties, then it is not eligible for patenting. But if there is a synergistic effect, then it is eligible for patent. Then so if it is just admixture, then it's not eligible. Synergistic formulations are patentable. And mere rearrangement of known devices, different devices existed, just you have combined them, then it is not eligible for patenting. Method of agriculture is not eligible for patenting. But agricultural equipment, so if you develop a new device for harvesting or for processing, then it is patentable. So agricultural equipments are patentable. And then there is also exclusion on any medical, surgical, other procedures. So because these are for public good, so it cannot be protected and made available only for those who have initially done this, so the knowledge has to reach others. But then medical devices, surgical, therapeutic or diagnostic apparatus or devices are patentable. So section 3J talks about plants or animals, but again here you have say clones and new varieties of plants. So essentially known biological process. So exclude patent on plants and animals in whole or any part thereof, including seeds or varieties. Essentially biological process of production. So if you make a hybrid, then of course though you have done something, then it is not eligible for patenting. And mathematical method, algorithms, computer programs, so these are not patentable because they can be protected by copyright. So these literary work, artistic work, they all come under the Copyright Act. And say a new method of performing a mental act, so this is also excluded. So learn a new method of learning or a teaching method. So these are again excluded under this. Any method of expressing information. So these are again excluded. Then topography of integrated circuits. So these are also excluded. And then there is also exclusion of traditional knowledge. But then if you have a new process for getting a product, as I mentioned earlier, extraction, for example, as a directive from Nitte, if you have a new process which is more economical, then you can patent the process, since process patent is allowed in India. And anything related to atomic energy, uranium, or anything having a radioactive material, that is not patentable, so there is exclusion. So what are the steps in obtaining a patent? So you need to write down the invention in great detail as possible, include drawings, sketches, diagrams explaining the work, and then check whether the invention is patentable. So for this, you need to do a prior art search, checking whether any published patent or technical publication may influence the patentability of your invention. So there are a number of patent databases, both paid databases as well as free databases for this prior art search. So here you have a list of free databases and paid databases, and you can use these. And now we have access to this Derwent paid database through this DST Nitte, so we are able to do that. So here we have the illustration of steps in patenting at Nitte, deemed to be university. So if somebody has an idea which may be patentable, then you provide information on the patentable product or process to the patent cell, which is now at the DS Nitte. There is a proforma for this. So this proforma can be made available. So it can be sent to this patent cell through the head of the institution. And then the patent cell, what we do is we do a prior art search. So we look at publication, we look at the patent databases, and we first determine the eligibility for patenting. And then this is brought to a technical evaluation by a committee involving experts in the field. Once it is cleared by this technical committee, then a patent application is drafted in consultation with the inventors. So in Nitte deemed to be university policy, the patent applicant will be Nitte University, but the inventors will have credit. The name of the inventors will be shown, and the inventors will still have right over their discovery. But all the costs related to patenting is borne by the university. Now, of course, the DST Nitte is paying for all the costs, and patent application can be filed online. And then once you file that application, you can file request for publication of the application. So this is also done by the patent cell. And the request for early examination is also filed by the patent cell. And once the examination is done, the objections will be raised by the patent office. This is a normal process. It's not that when you file an application, it will straight away accepted. There will be a number of objections, but you will have to respond to this and provide clarification. So this is done by the patent cell along with the inventors, and clearing all objections again done by the patent cell along with inventors. So once this is cleared, the patent is granted. So this is an example of a patent, published patent from our Honorable Vice Chancellor. This is for a mouthwash that is for managing radiation-induced oral mucositis in patients with head and neck cancer. So this was one of the first published patent from the university. So now in the normal process, patent publication happens 18 months after date of filing, but you can request for an early publication by paying an extra fee. This is what we are doing. So we pay this extra fee and request an early publication. So once it is published, of course, the information is available. So if anybody wants to contest it, they can contest it. So you will know where your application stands. Are there any objections to it? So you will have some idea about this. So there are advantages of having this published. And In the normal process, it is published on the 19th month in an official journal, which is made available in the website weekly. And yeah, the applicant has the option to request for early publication on request. And then examination. So again, normal examination takes place in 48 months, but we can file request for an early examination again by paying a fee. You can pay a fee for this early examination and file the request. So once this early examination request is filed by the applicant, then the patent office will send this patent application, the material, to an examiner, who will be an expert in the field. And the examiner has 1 month from the date of request for evaluating this. So examiner undertakes the evaluation whether the claimed invention is prohibited, whether it comes under any of the sections that exclude patentability, or whether it's eligible to be patented, and if it is eligible, is it an innovation that meets the criteria of patentability. So the examiner has 1 to 3 months to write his report, and once the report of the examiner goes to the patent office, the controller has 1 month time to deal with this, and the first examination report containing the list of the gist of objections is issued within 6 months from the date of filing the request. So from 12 months time from the date of issue of first examination report is available for the applicant to meet these objections. So you may have to modify your claim, or you need to provide more clarification to the patent office, so you have time to respond to these objections. So, as I mentioned earlier, there is also possibility of opposition of a patent. So you need to keep watching what is coming. So in the patent journal, so you just like you read your scientific journals, you can also go through this patent journal to see what the others are doing, whether it infringes on what you are doing or what you have documented. So when there is a opposition, the opposition is sent to the applicant, and the applicant has 3 months to respond to this objection from anybody opposing this patent application. And after examining the opposition and submission made during the hearing, the controller may either reject the opposition and grant the patent, or accept the opposition and modify or reject the patent application. So this is to be done within 1 month from the date of completion of the opposition proceedings. Then the grant of patent, a certificate of patent is issued within 7 days and is published. The granted patent is again published in the journal. So this slide summarizes the process. So you have filing of the application. It could be provisional or complete. And if it is provisional, then you have to file a complete application within 12 months. And then publication in the normal course 18 months, but you can request for an early publication. Request for examination, normal course 48 months, but again you can request for early examination. And examination and issue of the first examination report by the expert. And then you can have third party representation. And then the applicant has to meet all the objections raised or the oppositions made by any other parties. And if these are satisfactory to the controller of patents, then the patent is granted. So even after granted of the patent, opposition is again possible within 12 months. And then again it goes to the controller, and the appellate board will decide whether the patent is to be continued or it is to be revoked. So there is a fee. Even though the patent is granted, you have to pay a fee. There is no fee for first and second year. You will have to pay fee if you want to keep the patent active for up to 20th year as per the law. So you need to keep watch on when this patent renewal fee is to be paid. So this slide gives examples of the patents applications filed from Nitte deemed to be university. So there are so I think 7 patents which are published, and then there are a couple which are filed and which are awaiting publication, and there are some more which are in the process. So, in conclusion, what I would like to mention is that all faculty and staff who are associated with Nitte deemed to be university, do not underestimate your innovative idea. Sometimes you may think, oh, this is something very simple. It may not go for patenting, but you should always think that, okay, this is something worthwhile, and investigate whether it can go for patenting. So don't underestimate your own ideas or research findings. So don't feel shy. It may be worth patenting. So patent cell at DST New Tech is open for discussion and help with patenting. So we can do an early evaluation to let you know what you need to do to become eligible for patenting. So the DST New Tech has enhanced resources for patenting by subscription to Derwent database and also meeting the cost of patenting. And here we have the email. So if you need any support for patenting, you are always welcome to contact. Thank you very much.
Sir, extremely thankful to you for your wonderful, simple way of explaining the patenting process. Any questions? I don't see any questions on the chat box. Anyway, you have given your contact things. Friends, I think you can always visit our Technology Enabling Center, where Professor will be able to help us, as he has put it. Last year we had 7 patents, and this year we hope to file more patents. The last slide is very, very important, where he has explained we should change our mindset. We should not underestimate our own potential. Our ideas may become one day a process or a product. So we'll take it to things and try to file patent. And in the concluding things, I would like to say Dr. Karnasagar has explained to us what is a patent, what is a trademark, what is a copyright. And also he has explained to us about what is innovation, because we should differentiate between new process or a new things or a new way of doing the old things. And he has already explained to us the acts and the notification under that, rules under that. And the last, he was explaining to us the process of how a patent is filed, examined, the examiner's report, and you can counter sometimes. And really, it is educative, sir. On behalf of the Institute Innovation Council, I must say and thank you wholeheartedly for your wonderful lecture, simple way. And I hope our faculty and students will take advantage of you and your Technology Enabling Center to see that we can file more patents this year. And because many of us are working in different fields, research and things, and probably more people will approach you, and you'll see that as per the Honorable Vice Chancellor's remarks, this year we should be able to file more patents. Let us hope things happen that way. And I thank you once again for your kind support, sir. Thank you very much. And I will conclude this session with thanks to our Honorable Vice Chancellor and also all our members, Professor Nitte, Registrar, our IT team, Madam Bharati is here, Mr. Magesh is there for recording and helping, sir. Sir, Honorable Vice Chancellor has joined. Sir, you want to make any remarks, sir?
It was a very lucid presentation, easily could be understood by everybody. Thank you, Professor Karnasagar, for the wonderful presentation. and we could follow it very well. I think it's a nice. First lecture was very good in the series. I hope this process of having enlightened people giving presentation will continue. Congratulations to the Innovation Council, and thank you, Vidya Karnasagar, for the wonderful presentation. Thank you.
Thank you.
I must also mention all the members. Dr. Karnasagar has agreed as a part of the Institute Innovation Council activity, probably in the month of February. In batches, we will go to Technology Enabling Center to understand more about the activities and what is happening. I have already had requested him because the place is very small. Our members in batches and students in batches will talk to him and fix a suitable date so that the field visit to the Technology Enabling Center will also happen in the month of February. Once again, thank you, sir. Thank our Honorable Vice Chancellor and all of you for your support in organizing this orientation program. Thank you very much.